Rules Committee will come to order, and good afternoon. I hope everybody had a fruitful district work period. I know we couldn't wait to get back. Father, good to see you. Thank you. We appreciate you being here, and I know that many of you were able to take a look at people back home and wish them a happy birthday for our country, and hopefully to thank a veteran for their service to protect this great nation and first responders. I had a great time, and it even rained in Dallas, Texas over the weekend. Today, the Rules Committee will consider H.R. 4361, the Federal Information Systems Safeguard Act of 2016. H.R. 4361 is a legislative package from the Oversight and Government Reform Committee that enacts what I believe is much-needed good government provisions at different governmental agencies. Hardworking Americans should not have their tax dollars wasted to compensate poor-performing senior executives. Under this bill, senior executives will be subject to suspensions without pay for up to 2 weeks in cases of misconduct, the same penalty as other civil service employees are already eligible to receive with misconduct. This legislation also prohibits federal agencies from proposing or finalizing major midnight rules after the Election Day through Inauguration Day, with the exception of issues related to national security. Studies have shown that outgoing presidents from both parties have rushed through proposing or finalizing rules at the end of their term in the last minute. So we believe that regulatory review by the Office of Information Regulatory Affairs should be understood, and that we should not allow this. Since 1948, the volume of rules promulgated by outgoing administrations during the lame duck period averaged 17% higher than the volume of rules typically issued during the same calendar period. In other words, you get to the very end and it increases dramatically. This bill restores accountability of the executive branch by preventing those rushed and ill thoughts from becoming rules that are promulgated during lame duck sessions. This legislation also addresses the reports of government employees viewing pornography while at work and the deletion of records by the IRS. So I think the retention of information that will be in the interest of the taxpayer is being well served by this legislation. I want to welcome our first panel, obviously the gentleman, the chairman from Utah, Chairman Jason Chaffetz, and the gentleman from Virginia, that I suppose is you, Mr. Conley, thank you, and the gentlewoman from the District of Columbia, our delegate, Eleanor Holmes Norton. I want to thank all three of you for being on the first panel. Before we come to you, I want to say that anything you brought in writing, that objection will be entered into the record, and I'd like to defer, if I can at this time, to the gentlewoman, the ranking member, Mrs. Slaughter.
Thank you very much, Mr. Chairman. I don't have any questions, and just looking forward to testimony from my colleagues and ready to get back to work.
Here we go. Good. Well, here we go, Mr. Chairman. You're recognized.
Thank you, Chairman Sessions and the ranking member, Ms. Slaughter. And I thank the Rules Committee for the opportunity to speak about H.R. 4361. As amended, this bill combines 7 good government bills, each of which have been reported by the Oversight and Government Reform Committee. Broadly speaking, these bills address 3 key issues: enhancing federal information technology security, modernizing the federal workforce, and addressing federal regulatory burdens. The first topic, enhancing IT security, is addressed through the first bill and is championed by Representative Gary Palmer, who's also the sponsor of the underlying bill you are considering now. Specifically, Title I of the bill addresses the Federal Labor Relations Authority determination that was based on an incorrect interpretation of the Federal Information Security Management Act, also known as FISMA. This ruling permits federal employee unions to delay agencies from implementing timely and necessary cybersecurity protections, like blocking access to potentially dangerous websites, until the agencies first negotiate with unions over these changes. The second topic, the federal workforce modernization, is covered by Titles 2, 3, 4, and 5 of the legislation. Title II includes the text of H.R. 901, a bill introduced by Representative Mark Meadows, and requires the Office of Management and Budget to issue guidelines to prohibit access to explicit websites from federal government computers unless such access is necessary for investigative purposes. It's embarrassing and hard to believe that this committee and the Congress actually has to firm up this law, but the committee has heard numerous examples of federal employees spending significant amount of time viewing explicit materials on their federal computer during federal workforce hours and being paid by federal taxpayers. This included one individual identified by the EPA, the Environmental Protection Agency, Inspector General, who was watching, this person was watching 2 to 6 hours of pornography per day on a daily basis for an extended period of time. We've heard from the EPA administrator herself, they have a very difficult time in dismissing these employees. Title III includes the text of H.R. 3023, a bill introduced by Representative Ken Buck to lengthen the probationary period for federal employees to 2 years after training is completed. Currently, federal employees have a probationary period of just 1 year, which often does not give managers significant time to evaluate on-the-job performance and determine whether a candidate is suitable for permanent employment in civil service. Title IV includes the text of H.R. 4358, a bill introduced by Representative Tim Walberg to modernize the senior executive service, the elite administrators of the federal government. Specifically, the bill will increase the probationary period for SES members to 2 years and make SES members subject to the same suspension authorities for misconduct that already apply to the other civil service employees. Additionally, agencies will be able to remove SES employees for, quote, such cause as would promote the efficiency of the service, end quote. Again, the same standard as already applies to other civil service employees. In fact, the majority of the civil service employees. Title V includes text of H.R. 3023, a bill introduced by Representative Dennis Ross to require the Office of Personnel Management to release an annual report on the use of official time by agencies. Official time is when federal employees perform representational work for a union in lieu of normally assigned work. While OPM has provided some statistics on the use of official time throughout the federal government, the data is often untimely and does not help Congress in overseeing and exercising its oversight duties. This would be an annual report. The third topic addressing regulatory burdens is covered by the final two titles of the bill, Titles 6 and 7. Title 6 includes text of H.R. 4612, a bill introduced by Representative Tim Walberg to prohibit agencies from proposing or finalizing rules in the period between the day of a presidential election and the inauguration day of a new president. This provision will address a recurring problem on both sides of the aisle, where sitting presidents from both parties rush through the regulations at the end of their term, which have been known as midnight regulations. To counter the problem of midnight regulations, every president since President Reagan, who has taken over from the opposite party, has issued an immediate regulatory moratorium to pause the regulatory process until it can be reviewed. Rather than enforcing an incoming president to handle a torrent of new regulations advanced by an outgoing president, the bill will allow new presidents to move forward on regulations as they determine appropriate. Title VII includes text of H.R. 4921, a bill introduced by Representative Mark Walker to require the IRS, the Internal Revenue Service, to mirror what the agency requires of taxpayers in its own record-keeping requirements. Specifically, the IRS requires taxpayers to keep their tax year information for 3 years after filing. Under the bill, if the IRS requests any of the information it requests to be preserved by taxpayers, the IRS too should be required to keep that information, as well as any records generated as a result of that information for at least 3 years. In closing, these bills make significant reforms to improve how our government works. We had a good open process in our committee. We're pleased to present this bill to the Rules Committee today. Thank the Chairman.
Mr. Chairman, thank you very much. Mr. Conley, you're recognized.
Thank you, Mr. Chairman. And thank you and the ranking member and the members of this committee for your customary courtesy in receiving us. I appreciate it. I appreciate the opportunity to testify on H.R. 4361, the Government Reform and Improvement Act of 2016. This legislation is a collection of 7 anti-federal employee and regulatory measures that the Democrats on the committee strongly oppose. This legislation is not about government reform. Rather, it is an attack on federal employees and the President. It would undermine federal employee due process protections, enable retaliation against whistleblowers, override collective bargaining rights, and block the president from exercising his constitutional authority to finalize rules even during his last month in office. Now, if he's a lame duck, so are many in this Congress. The logic that the president should be defenestered because he's a lame duck would also presumably apply to members of Congress who aren't seeking re-election or are defeated. Maybe we should take away their vote. No, none of us would agree with that. We're duly elected and constitutionally sworn, as is the president, until the set date in the Constitution of the United States. Titles 3 and 4 would reduce due process protections of new employees and senior executives. Title 3 and a provision in Title 4 extend the probationary period from 1 to 2 years for new federal employees and executives, making them essentially at-will employees during this period with limited due process or appeal rights if they are fired or disciplined. The Oversight Committee's investigations of whistleblower complaints have confirmed that extending the probationary period would make it easier for agencies to retaliate against employees. Now, I don't believe that's the purpose, but that's the unwitting consequence. For example, the Oversight Committee recently held hearings that examined the extent of whistleblower retaliation in the Transportation Security Administration and the Department of Interior. Extending the probationary period by making them at-will employees further exacerbates a problem that could clearly exist across a variety of agencies. There's also no evidence that an across-the-board extension of the probationary period for all federal employees in all occupations is required. The Oversight Committee has held no hearings on that matter. Both the Merit Systems Protection Board and the Government Accountability Office have studied agency use of the current one-year probationary period. Interestingly, what they found was that managers and supervisors have not been effectively using that one-year probationary period to identify and remove underperforming employees. So why should Congress actually double that probationary period for federal employees if MSBP and GAO are telling us that managers are not even making sufficient use of the current authority of a one-year probationary period? Shouldn't Congress be exploring ways to encourage managers to fully utilize that existing probationary period before we double it without empirical evidence to justify it? We're also troubled by the constitutional deficiencies in Section 407 and Title 4 that would allow senior agency executives to be removed almost immediately with only minimal appeal rights. It would presume guilt by allowing for removal before a senior agency executive is given an opportunity to challenge the charges. It would also not allow the administrative judge's decision to be appealed to the board member of the MSPB in violation of the Appointments Clause, and the agency's decision would become final by default if the judge is unable to issue a decision within 21 days. Identical provisions in the Veterans Access, Choice, and Accountability Act of 2014 are currently being challenged in the Federal Circuit Court of Appeals, and the Department of Justice recently announced it will not defend the constitutionality of some of those provisions. Title VI. Title VI would bar major regulations from being proposed or finalized during the last few months of a president's term, as we just heard. This moratorium would apply no matter how long a rule has been in the rulemaking process. Some rules have been in the works for years, and yet this bill would block those rules simply to frustrate the outgoing president's policies. It's important to note that Senate Republicans have stated they will refuse to hold a hearing on President Obama's Supreme Court nomination. Unprecedented. These actions cannot be viewed as anything other than another set of attacks on this president's authority to act through the end of his term in January 2017. I remind the committee that Section 1 of the 20th Amendment states, "The terms of the President and Vice President shall end at noon on the 20th day of January. Until that time, the President and his administration have the responsibility and the authority, as duly elected by the people of this country, to continue to protect our health, safety, environment, and economy, as do lame duck elected members of Congress." As for the remaining titles of the bill, Titles 1, 2, 5, and 7, let me just quickly mention that they are unnecessary in our view, because there are existing policies, practices, and rules that address those issues. These provisions, from our point of view, do nothing to advance reform. I urge the committee to adopt an open rule for H.R. 4361. If the committee instead chooses to adopt a structured rule, I ask that the amendment submitted by my friend, from whom you're about to hear, Eleanor Holmes Norton, the delegate from the District of Columbia, to strike the problematic sections of this bill be made in order. I also ask that the committee make the 3 amendments submitted by Representative Bonnie Watson Coleman, also a member of our committee, also in order. One amendment would require GAO to do a study on whether an extension of the probationary period is in fact required. The second amendment would exempt from the moratorium imposed by Title VI any rule that's been included in the U.S. regulatory agenda for at least 1 year. The third amendment would strike the language in Title V requiring the Office of Personnel Management to include in its annual report on official time a description of any space designated at agencies for official time activities. Mr. Chairman, in anticipation of a hopeful response on approving those amendments, I have myself restrained myself and offered no amendments to this bill. I thank you for your patience and your understanding.
Ms. Connolly, thank you very much. Ms. Holmes Norton, you're now recognized. Welcome.
Thank you very much,
Yes,
Mr.
ma'am.
Chairman. And may I say how delighted I am to be before this committee on a matter not involving interference with the rights of the District of Columbia. I am here, however, on a matter of considerable importance to federal employees. My amendment would strike certain sections of the bill, 402, 405B, 406, 407, and 408. While some reforms to the senior executive service surely must be necessary, we should be looking for them, these sections go much too far by rolling back significant due process rights for federal employees and raise potential constitutional issues. In fact, this bill is replete with constitutional issues. Section 402, which lengthens the probationary period for SES employees from 1 year to 2 years, is patently unnecessary. There's no evidence to support it. The agencies who want to deal with poor performers in the workplace, according to a 2015 GAO report, already use probationary periods, but the GAO says they could use them more effectively. This is within our grasp to make happen. Of the 3,500 federal employees that were dismissed in 2013, the majority were dismissed during the probationary period. Supervisors are at pains to get rid of such people when it is easiest to do so. So instead of extending the period, we should be looking at ways to improve its use by agencies to ensure that the federal workplace is operating at its best. Section 405B is even more problematic. This section would allow an agency to remove an SES employee from civil service entirely for poor performance. Now, we know how the civil service works. You're promoted up the ladder. Under current law, poor performing employees instead are downgraded to a GS position, a level at which they might perform very well, even if in this test period they prove to be poor performers at the SES level. Remember, we have invested considerably in these employees by the time they are even considered for the SES level. This section would also shorten the notice inexplicably from 30 days to 15 days. I don't know what the purpose of that is. because it makes it extremely difficult for affected employees to exercise their due process rights. Section 406 raises a serious constitutional issue by giving agencies the authority to place an SES employee on mandatory leave. That's one, all right, but forcing the employees to use their own vested accrued leave is not all right. This provision violates basic constitutional principles. It is likely a taking of an earned vested property right, or in the alternative, it is a suspension that triggers due process rights. This mandatory leave provision has little chance of withstanding constitutional scrutiny and should be struck now. Section 407 further represents an attack on federal employees' due process rights. This provision expedites the removal and appeals process and adopts provisions of other federal law that are currently being challenged in the federal circuit. Why are we rushing? Let's see what the courts have to say. Section 408 requires reassignment of SES employees to different geographical locations, which is arbitrary and flexible and ignores the needs of individual agencies. This provision is unnecessary, given action that the President has already taken by signing an executive order in November of 2015 that would strengthen the senior executive service by requiring agency heads to develop a 2-year plan for increasing the mobility of SES employees. We are not saying they should not be removed, but to simply up and arbitrarily move them halfway around the country without the kind of thoughtful process the executive order envisions is terribly problematic and unnecessary. Therefore, Mr. Chairman, I urge you to make my amendments in order. And I say I'm quite open to reform legislation to deal with poor performance. That is not an issue for me. But we cannot do so by willy-nilly rolling back due process protections for federal employees who, after all, are covered by the Constitution of the United States. I thank you, Mr. Chairman, and yield back.
Thank you very much. I'd like to note that we have, there was a prior conversation with the Chairman Chavez, who indicated that he would need to be at a 5:30 meeting, and I advised him that he needed to have someone here who knew what they were talking about. And one of the authors of one of these sections from the bill, Mr. Meadows from North Carolina, has appeared, and I was aware that you'd be here. Mr. Meadows, welcome to the hearing. And so we're going to now take questions. Did the gentleman wish to make any opening statement? Great, thank you very much. I've got a question, if I can, please, ma'am. You spoke about Section 404, and I note the changes that were made are two. Section 404. Yes, ma'am. Section 404, there were two changes. One was made striking the two words "on" or, and by adding the word "not later than 30 calendar days." On or, and what was added was, perhaps, Mr. Meadows, this was your work, more specifically, not more than 30 calendar days. On or. Not later than 30 calendar days. Isn't that more specific, to be specific about the performance appraisal? Instead of on or, they added not later than 30 calendar days. And you took exception to that.
Yeah, my exception was from 15 to 30 days, Mr. Chairman.
Section 404, I'm looking at Section 404 here. Section 404, under page 10.
Because I'm looking at my testimony
Yes, ma'am.
for 404, and I do not see 404 discussed.
Okay, I'll see if I can give this to you. And the second was by inserting the word "in writing" as opposed to
In which
"communicated."
section was that?
I'm going to ask that the clerk please take this down to you so that you have a chance. And I could be
Because I
looking,
spoke to sections 402, 405B, 406, 407, and 408.
I heard you speak about Section 404.
No, sir.
You did not speak about Section
No,
404. Then I
Because
stand
I only
corrected. I'm
spoke on
sorry.
my
I
amendments.
I marked it as you were going down. I thought you referred to Section 404.
Mine only involved certain amendments, and 404 was not one of them.
Not one of those. Thank you very much. Mrs. Fox.
Thank you, Mr. Chairman. I appreciate our colleagues for being here today and presenting this good legislation. I do not have any questions, and I yield back.
Thank you very much. Mrs. Slaughter.
Thank you, Mr. Chairman. I read hastily here, but what I saw was the reduction of something from 30 to 15. Is that what you were talking about? On removal?
Yeah, I think Mr. Conley needs to speak to that, because frankly, I didn't have 404 as an amendment.
Did you?
That
Well, I just read it
That I asked to
here.
be made in order.
Yeah. Okay. Just to clarify, it doesn't, you don't have to.
You're asking me to address something I don't think I addressed.
If I am wrong, I'm wrong. I heard the word Section 404 and some dialogue related to it, so I went to it and looked at it as one of the first ones talked about. I'm not trying to make an issue if the gentlewoman did not bring it up. I can go back and look at the.
I didn't bring it up because that's not one of the.
I'm perfectly willing to say, thank you very much.
Shall I go ahead? Just as a matter of my information, because I'm really not aware of it, but I don't recall any time in the many years I've been here that we ever micromanaged employment like that. Is that appropriate? Is that what we do? You have to have legislation to determine how long probation is and what people do on their spare time and all that sort of thing. Is that, yes, I guess, but let me preface the question with, do you expect Senate action on this bill?
Well, certainly, I would hope
Well,
it's
do you
good,
have some,
responsible
do you have any
legislation.
indication that the Senate will take it up?
Well, obviously, there are components of this bill that we've talked to some of our Senate counterparts, and they find it real interesting. One of the particular functions is some of this legislation actually comes out of talking to the rank and file. As you probably know, I've been.
But is it a function of Congress was really my issue.
Well, the prohibition against, what we have been led to believe is that there are many people who would manage their own agency better if some of these issues were not in there. And give you a prime example.
Well, I can understand that would be possible, because we've seen some agencies that we all thought we could improve. But do we do that legislatively, or isn't there some other system by which they determine how they are going to function with their employees?
I can tell you that I have reached out in a number of cases to try to make administrative fixes, and it's only as a last resort, because of the laborious process of actually passing legislation, that we would actually defer to a piece of legislation. Many of these are because of problems that are inherent within the agencies, or in the case of the length of time for probation. To give you air traffic controllers, are a prime example. Their training process is actually longer than their probationary process, so we don't even have a chance to evaluate them until they are already a full-time employee. And so it addresses some of those issues. Obviously, we've tried to do that in the least restrictive and least cumbersome way that we can.
Well, I can tell you a couple agencies that have some problems. I just heard the craziest story I think I've ever heard since I've been in government, that we have cut the budget so much for the IRS that one of the employees had one of those black clocks up on the wall, the electric clock that we've all had for 30 years.
You mean one like I've got in my office?
Right, and hers fell down and broke, and there's not enough money in the budget for the IRS to replace that clock. And we do know that NIH is suffering over there because they don't have enough money to complete the Zika vaccine. So there are a lot of problems here, but a lot of them probably start in the Congress. the way we handle our money and the budget and what we do.
Well, I can assure the ranking member that I look forward to working with her on NIH funding. Has been something
Well,
near and dear
there are
to
a number
me.
of things. Infrastructure in my part of the country
I
is
was
desperate.
I was one of the few that passed the 5-year transportation bill, so I look forward to working with you in a bipartisan manner.
They just tested lead water in all schools in my district, which has always been pretty well-to-do and taking good care of things. And the lead problem there is really serious. And, I'm pretty sure the city of Rochester has a lot of water pipes that are brick and over 100 years old. So we got a lot of
Well, we
problems that
share
ought to
roots
fix.
going back to
I would
Burnsville.
rather we would spend time on that, let me just be quite blunt about it, than this.
The gentlewoman's point is well made.
Right. Thank you, and I yield back.
Gentlewoman Jill back to time. Thank you very much. Chairman Cole.
Thank you, Mr. Chairman. It's always good to see my three friends, but Oklahoma City lost Kevin Durant yesterday, so I'm in mourning, so I have no questions for any
The gentleman yields back his time. Well, Father Conroy's here, so he may be able to console you a little bit there, Tom. Yeah, well, these are big issues. That's a big issue. Kevin Durant is a good basketball player.
He's a great person.
Yeah, oh, I'm sorry, probably a big person, yes. Gentleman from Georgia.
Thank you, Mr. Chairman. Well, we've got some fine agencies in the great state of Georgia. We've got a wonderful NSA facility down there. Of course, we have the CDC down there. The list goes on and on. I will tell you, it disappointed me to hear this bill described as just a blatant attack on federal employees. I would tell you that the most disappointing thing that I hear from the federal employees in my district, I certainly don't have as many as Mr. Connolly does, but they work awfully hard and they do good work. It's about morale and what a rotten thing it is to show up at the CDC every day, working hard to do things that everyone in this room believes in and is going to benefit from, and getting tarred with a do-nothing, watching pornography, can't ever be fired, wasting the taxpayer dollar, federal government employee label. All federal government employees are not created equal, and to not even be able to look at someone post-training within a probationary period, I would have thought would have been one of those things that would have brought us together rather than divided us. I say to my friend from New York, lots of other things we could be legislating on, but yes, we put into law 1-year probationary periods in order for the FAA to let the training process finish before it evaluates someone's success. And in the spirit of due process, I think we should let the training process finish before we judge whether or not someone is able to complete their job. Requires a change in federal statute. We put it in there to begin with, and the only way to fix it is to change this. I'd ask Mr. Meadows, we certainly see a lot of executive actions that do things. I don't think that we can change a U.S. statute of this kind with executive action.
Well, we can't. I've looked at that from an administrative standpoint, and the gentleman from Georgia says it well, is we've painted a very broad brush for many of our federal workers, and I've been trying to work very closely with my good friend from Virginia to make sure that we change that. And part of what I'm hearing is that sometimes the bad actors get away with really what the agency and the workers around them would not allow to happen. And we've got to address that, hopefully in a bipartisan way. But it's time that we acknowledge the great work that so many of our federal employees do. But if we could do this administratively, I think it would have already been done.
And would my friend yield? I thank my friend from North Carolina, and I don't know that there's a lot of daylight between us on those goals, and yours and mine. As you indicated, I think I represent the third largest number of federal employees in the United States. Obviously, performance metrics matter, and having the flexibility to respond when something untoward occurs in the workplace is very important. But candidly, the problem my constituents describe is not a whole bunch of people watching pornography at the office. They do. You want morale problems, Mr. Woodall. It's about sequestration, and it's about the threat of government shutdowns. That is a morale killer. And I'd be glad to make my constituents available to share those morale problems with any member of Congress who'd like to discuss them.
I guess
thank my friend for yielding.
I hear conflicting statements. On the one hand, I hear that a one-year probationary period is plenty of time to determine whether or not someone is quality. We don't need to extend it to 2. And then on the other hand, I hear that these other folks who have already passed their probationary period, who are now enrolled in management, are apt to use a longer probationary period for nefarious goals, that they can't be trusted to use a longer probationary period because they would use it to thwart someone's due process rights. Well, I would say only one of 2 things can be true. Either we missed a few bad apples and got them up into the management chain, where they're now trying to bend the rules to thwart employees' rights, not because they're bad employees, but because they have an axe to grind, in which case we should find a way to go after middle management, or we actually have a junior employee who's not ready. I just, again, this seems like an area that we could come together on. I would say to my friend Ms. Holmes-Norton, you mentioned the SES positions. As if we were going to run someone out of civil service altogether instead of just demoting them to a place in civil service where they could perhaps perform better. They do say we all get promoted one level above our competency, and so I certainly recognize how bringing somebody down could make it work. But my reading of the bill is not as you described. My reading of the bill is that it would do 2 things. Number one, it would certainly allow folks to be demoted into civil service if that's what management decided. But it also allowed someone to be removed from civil service altogether for misconduct, defined as neglect of duty, malfeasance, and failure to accept a directed reassignment. We're not talking about folks who just underperformed because they were promoted too rapidly. We're talking about folks who were involved in malfeasance, who could be demoted to civil service, but for whom there could be malfeasance that is so grand, we now would allow a new system to remove someone from civil service altogether, because doesn't it seem odd that you would commit an act so egregious that your punishment is that we're just going to give you a different job? Instead, shouldn't there be some acts that you could commit that we should agree that, you know what, the federal government's not for you. We should be able to look somebody in the eye and say the taxpayer deserves the best, and you're not it. And I guess my question is that not a place of agreement? Can we not agree that there should be some folks, that there should be some actions that are so egregious that we should allow, once due process has been fired, to remove someone from federal service permanently, rather than to simply slap them on the wrist and demote them for this egregious act? And I would think, again, we could find agreement there.
Well, I would think so. For example, the operative word in your question was egregious. If there is an egregious matter involving a federal employee, it shouldn't be downgraded. We're talking about, and here are the operative words in my statement, this section would allow an agency to remove an SES employee from civil service entirely for poor performance. Now we have somebody who was a great employee where they were. So you have to do a guesstimate. He'll be great above that. It's only poor performance that my amendment would involve, because I agree with you. Then what the federal government, if this person had committed acts which are egregious in some way, it should use the government's right to, in fact, eliminate that employee entirely from the service. And I was not trying to protect that employee in my amendment, and I think we could get together on my amendment.
Because as I read the language, it says exactly what you describe it as saying. It says under misconduct, it says, if the head, this is the agency head, so removes such an individual, the head may, in the case of an employee described in paragraph 2, transfer the employee from the senior executive service to a general schedule position at any grade of the general schedule for which the employee is qualified and the head determines as appropriate. That seems
Mr.
like
Woodhull,
exactly
my
what you're
amendment
requesting.
simply says that ought to be the first way to handle poor performance, not to take years of investment in that employee and off with his head. go the downgrade. And that's all my amendment would say. If in fact more is required, nothing would stand in the way of the agency head, in fact, getting rid of that employee. We're talking about only poor performance. Geez, you are a good employee. You were doing so well at the GS 14 level or whatever, but you're not ready to be a manager. That is a very different set of skills, and often it is impossible to judge that skill before someone takes the helm. Now, Mr. Woodall, I must say to you that it was amazing to hear you talk about the morale of the federal workforce, and then to talk about people talking about people sitting and doing pornography, as if some of the issues that Mr. Connolly raised weren't really what was on federal employees' minds. Do you realize how badgered our federal workforce feels? This is the finest public workforce in the world. These are highly educated people, overeducated people, and yet time and again they become the object of the brickbats of the majority. So their morale is not down because of people who have been misusing government computers for morale. I say off with their heads. Their morale is down because of pay cuts, because of pension cuts, because of sequester, and because, frankly, they feel undervalued. So I wish this committee would help us to raise the morale of this very valuable, this invaluable workforce that we're so fortunate to have.
I have always said that if we spent more time working on those things that bring us together, we would have more energy and more trust to work on those things on which we may be further apart. I just would have thought that ridding the federal workforce of those caricatures of the federal workforce would have been something that brought us together so that we could celebrate that greatest
It does bring us together.
workforce.
Let's get rid of the pornographers.
Mr. Meadows?
Mr. Woodall, I want to stress two things. One is I didn't hear anywhere in your questioning a disparaging remark about the federal workforce, and I appreciate that. And I think the underlying message that needs to go out is that we do appreciate our federal workforce. But perhaps the best context for this debate is actually from the federal workforce. In 2015, I pore over the surveys that our federal workers put forth. And in 2015, that survey, and let me quote, "In my work unit, steps are taken to deal with a poor performer who cannot or will not improve." Only 29% of federal workers agree with that statement. So that is not the gentleman from Georgia saying it. It is not the gentleman from North Carolina or Virginia or the District of Columbia. It is our federal workforce who says that only 29% of our federal workforce thinks that we deal with poor performers adequately, and that is something that we have to address. So I thank you. I yield back.
I appreciate the committee's work. I appreciate the effort to find some common ground here. I hope we'll be able to consider this and make some amendments in order for a full debate tomorrow. Mr. Chairman, I yield back.
Gentleman yields back. Gentleman.
Mr. Chairman,
Yes,
I appreciated Mr. Woodall's comments, and I would ask him to look closely at my amendments and see, even if there are some changes that he deems necessary, whether or not some could be made in order. Otherwise, I was just handed the SAF, the Statement of Administrative Policy, which says if the president were presented with H.R. 4361, his senior advisors would recommend he veto the bill.
Yes,
Let's do a bill that he won't veto.
Yes, ma'am. Thank you very much. Mr. McGovern.
Yeah, well, I wanted to thank the witnesses for being here. I was on the floor, so I'm going to spare you my questions, but I will ask unanimous consent to insert the Statement of Administration
Without
Policy in the
objection.
record, so it's there, and I hope that Mr. Norton's amendments, and as many amendments as possible, can be made in order. So yield back my time.
Thank you very much. Dr. Burgess.
Thank you, Mr. Chairman. I, too, was on the floor, so I missed the better part of the debate. Thank our witnesses for being here, and I'll reserve my questions for later.
Thank you very much. Does any other Republican seek time? Gentleman from Ohio.
Thank you, Mr. Chairman. I appreciate you holding this hearing. Appreciate the great witnesses for being here. And I'd like to ask the gentleman from North Carolina, because I heard some comments about, gee, Congress is micromanaging when we create a 2-year probationary period. wouldn't you think of Congress like the Board of Directors of the United States? And don't Board of Directors set out big policies and then let the managers in the agencies run the agencies? And isn't establishing a 2-year probationary period a policy that a Board of Directors or a body like this should engage in, and then let the agencies decide individual decisions? This isn't micromanaging, this is setting a policy, isn't it?
Well, the gentleman says it and states it well. Here's the interesting issue, is when you set these overarching principles and you trust the federal workforce, whether it be at the management level or indeed at the rank and file level, to improve the agency, what I have found is that overwhelmingly they come up with the best ideas, they come up with the most progressive ideas, and honestly want their ideas implemented. One of the interesting things on the best places to work on the survey, as we look at that, they get points for actually implementing the ideas within the agencies. NASA performs extremely well. There are others who do well, and the gentleman from Virginia and I have focused on that. I took some criticism early on because I had the worst places to work. We changed the title. We've gone through that to make sure that we're rewarding those best performers. So the gentleman states it well, and really this is overarching principles that would be pragmatic in any business environment, and certainly one that we expect our federal workforce and managers to carry out. I yield back.
Thank you. And to the gentlelady from the District of Columbia, I was just looking through your amendment, which is pretty simple. It strikes 5 sections of the bill, 1 subsection and 4 whole sections of the bill. Tell me why help me understand again why you don't think Congress should set a policy like this. You just think this is punitive, or I don't want to put words in your mouth. Tell me why you... Help me understand. Your whole amendment, yeah, that strikes section 402, 405B, 406, 407, 408.
Which says that the problem is not with the length of the period, but with the use of the period. And therefore, I would like to see the period used. Now, oversight seems to me without a change in law could get that done.
So, back to the gentleman from North Carolina, I know one of the other members asked, that can't happen without a change in law, can it?
Well, it can't happen without a change in law, and I think the gentlewoman, her reference would be that she wants us in oversight to micromanage it more than we're doing. This is setting overarching policies without us going in to say, and certainly if we see abuses of that, I'm willing to work in a very bipartisan manner. I can tell you some of my newest found friends are those of the federal workforce, and in doing that, trying to make sure that we encourage them to not only do a good job, which I believe they are, but also acknowledge that. And certainly that is preaching to the choir on my side of the aisle. We're trying to do that. But this cannot be fixed administratively, and that's why we need the legislation.
I agree with the gentleman. It can't be fixed administratively because it doesn't need to be fixed. Again, I'm relying on an objective source, not the Democrats or Republicans, but the GAO looked at this issue. And we are in the business, sir, of oversight. So if they indeed are not using the probationary period as effectively as they might, and even though 3,500 federal employees were dismissed, for example, in 2013, then what oversight is for is bringing the agency and saying, how come, let me hear your response to the GAO report, which says you are ineffective in using the time available to you. So to disregard the GAO report and say all I need to do is add more time to it is not to give a reason or a fix for what is wrong with the probationary period.
Since I haven't read the GAO report, I'll ask the gentlelady from the District of Columbia, does the report, those two things are not mutually exclusive. Just because you're not using the probationary period to your greatest impact or effect does not mean the length of period does not need to increase. Those are two separate and distinct issues. I don't think that I would necessarily agree or disagree with you. If the GAO says they're not using the period to its full impact and effect, and not using it to the best of their ability. That may very well be true, but did the GAO report explicitly say that we don't need to extend the period? Because I don't think it did, but I haven't read it, so.
It certainly did not. But the
Okay.
whole point of looking at the probationary period was to make recommendations. It did not recommend that the probationary period be extended. It did recommend better oversight, sir, of the use of the existing probationary period. Look what you're doing. You're making these into at-will employees, all of them now. You ought to have a very good reason for doing that, when a small number of them may need the kind of oversight supervisors are paid to give.
So the GAO looks at what we asked them to look at, and I don't know what they were asked to look at. They probably were asked to look at whether the probationary periods were effective in their current form, and they probably weren't asked to look at whether the probationary period should be extended. Maybe
Well,
they
in the
were,
spirit-
maybe they weren't, but if they
And-
weren't asked to specifically look at that, the GAO doesn't look at things that we don't tell them to look at. They're an arm of Congress that looks at what we ask them to look at. So, again, I am at a disadvantage because I haven't had a chance to look at the GAO report, but at the beginning of every GAO report, it says what they were tasked to do, and so I will definitely go back and take a look at that. I am disappointed that we can't get our arms around, in a bipartisan way, how we can help make the federal workforce better, because frankly, we have a lot of incredible, hardworking men and women in the federal workforce in all of our districts, all around this country, and I respect them, but I think it does a disservice to them when we spend too much time fighting about maybe the bad employees, and we should be honoring and figuring out how to laud accolades on the effective, good servants, and rid ourselves, as the gentlelady from the District of Columbia said, of the people who are cheating the federal government or just not effective and not doing their jobs. So I would hope that we can all work together to do both of those things, because I don't think those things are mutually exclusive. So I would look forward to trying to work with the gentlelady from the district, the gentleman from Virginia, and the gentleman from North Carolina, because I think we can do those things together, and I hope we will.
Could
Go ahead.
Could I simply say I appreciate your remarks, and while I do not remember, but I am almost certain that you are correct, that they were asked to look at the probationary period. So I would think that the answer to bring us together would be to ask them to look at the length of the probationary period and to say to the chairman of the subcommittee whether enlarging the length of the probationary period might help to improve performance of the agency and of probationary employees, not to, with no evidence whatsoever, to assume that the answer must be to lengthen it to twice what it is at the moment. Thank you.
Yeah, and the only thing I would say, and I respect that and appreciate your comments, I'm not sure that it does harm to anybody who is a good federal employee to lengthen the probationary period. There's nothing to be feared of a probationary period if you're doing a good job and you're a hard worker and you're learning your job and you're serving the taxpayers. There's nothing to fear, is what I would say. I would yield, yes, sir.
I thank my friend. I think you raised some really good points, as did Mr. Woodall, in terms of accountability and performance. As somebody who ran a county, that matters to me in governments. But stipulating that everybody involved here is trying to do the right thing, surely you can understand at least some of the concern of the Democrats who did not support this bill. If we want a bipartisan bill, let's make it bipartisan. We don't support this bill. The president's threatened to veto it. So you know, and it isn't just about bad actors and pornography in the workplace. There are other provisions here that are troubling to us. And protecting the rights of workers is not a trivial issue and ought not to be for any of us. If we're going to make the federal government an attractive career path for the next generation, we've got to make sure that it is perceived as a fair workplace, not an arbitrary workplace. It's hard enough right now given the punching bag the federal workforce has been made into in the last number of years, to frankly attract the talent of the future in sufficient numbers. You know, and your point about shouldn't we have the ability to, is in an extended period of time, which is a little odd. And yeah, GAO wasn't asked, well, given the fact that you have looked at 1 year and found that it's underutilized and not even used properly as a management tool, how about we double it then? Well, why not make it 10 years while we're at it? Why not provide no protection whatsoever to the civil service and return ourselves? I know you're not saying that, Mr. Stivers, but I'm asking that question rhetorically to make the point. Protections are in place for a reason. Abuses occur on the other side, too. Our committee's had hearings, as my friend from North Carolina I know knows, and is sympathetic with, the plight of people who are subject to arbitrary treatment by managers. There was an article just yesterday, I think, in the Washington Post about such an example in the National Park Service, Cape Canaveral, Grand Canyon. So it happens. So making sure protections are in place, there's a reason why Congress did that years ago. And there's a reason why we should tread carefully on those rights and the right of due process, the right of appeal, protection from arbitrary removal by maybe a prejudiced or politicized manager. There's a reason for it. And so I think we could find common ground. Sadly, I don't think this bill does it.
Thank you. I appreciate that. And, you know, I live in a employment at will state. So private sector employees in Ohio, and I think about 30 states across the country, have no protections. And it used to be when I was growing up and when my father was in the workforce, people would go to the public sector, to the federal government, because it might pay a little less, but it actually provided more employment protections. It still provides a lot more employment protections than the private sector, but today, and I'm surprised to hear my friend from Virginia say that the federal workforce is someplace that people don't want to come. Today, if you look at studies, the federal workforce not only has better protections, it pays better than the private sector. So it's a great career, and we have a lot of incredible people going into the federal workforce, and we want to keep those, but I don't think it should be such a partisan issue to get rid of the bad ones. So I'm sorry it's devolved into that, and I would hope we can work together, and maybe we can find some common ground in the future on this. But I do think this is a good bill, and I yield back the balance of my time, Mr. Chairman.
Thank you very much. The gentleman from the state of Washington, Mr. Newhouse.
Thank you, Mr. Chairman. Good to see you all from coming back from 4th of July break. I do have to say I relate to the gentleman from Oklahoma. Mourning the loss of a player has got to be terrible. We in the Pacific Northwest are still mourning the loss of a whole team, which the gentleman from Oklahoma knows something about.
The gentleman yield?
I'd be happy to.
You want some free advice? Build them a new stadium now.
Well, our taxpayers had something different to say about that. But well, this has been certainly appreciate gentlelady from the District of Columbia coming to help, I think, perfect a bill, an important issue that it seems like we all do have some common ground on. The issue of due process has piqued my attention. That's something we all hold very dear. We all strive to protect, and been a great discourse back and forth about that. And I just wanted to, Ms. Holmes Norton, you did make a couple of points within your comments about due process being tread upon here, and I wanted to ask if I could, the gentleman from North Carolina, to expound a little bit about your response to the good lady's concerns about due process in the underlying bill.
I thank the gentleman for his question. Obviously, as we looked at crafting most of these bills, the interesting aspect that we seem to be debating back and forth here has to do over a probationary period that would not only not trample on due process, but part of that GAO report that the gentleman from Ohio was talking about was that as we started to look at that, it being underutilized was the fact that managers typically didn't use that. They didn't want to make a decision. They wished they had a little bit longer period in order to evaluate. So the causal effect is one of two things. Either you do nothing or you make an arbitrary decision to let someone go during the one-year probationary period, which may not be in the best interest of the agency or the employee. And so while the gentlewoman makes those claims, I would suggest that in the text of this particular bill, that it actually allows for additional protections for our federal workforce in every way. Being one who will probably debate due process this week, it is something that is near and dear to my heart, and if it were something that we were overreaching on, it would be something that I would stand up and join the gentlewoman in a bipartisan way to oppose, but I don't see that in the underlying bill.
Could I respond?
Please do, please do.
Because I did, of the various sections I asked you made in order, to be sure, one had to do with extending the probationary period. Let me say for the record, that does not raise a constitutional issue. When a constitutional, that is in our discretion, and I concede that. Where a constitutional issue was raised, I said so. For example, this is an interesting one, but it'd be interesting to see how the government would, while the court would treat it. Employees are required to take mandatory leave often while they're being investigated. That's one thing. But to force an employee to use their vested accrued leave is quite another. Now, it's vested, it's accrued, it's earned. Suppose the employee says, I'll take my mandatory time. That's what's required, you can give me that. You can't take my leave, that's money, that's what I have earned, that's my time off. I think that raises a real constitutional issue and could be a taking if presented to the courts. Why not? Let's come to a way to deal with that. Why not give the employee an opportunity to use his vested leave or be put on mandatory leave without using his vested leave? Give him the choice.
Well, could I add one more thing, if my colleague would yield?
That would be fine, that'd be great.
There are other constitutional issues, I think, in this bill, and we're kind of not talking about some of them. One of them is blocking the president from issuing rules during his last months in office. I believe that's, on its face, an unconstitutional impediment. It goes right at separation of powers. And as I said in my testimony, if we're going to apply that to the executive, why wouldn't we apply it to ourselves, which would also be unconstitutional? But, I mean, why is his action as a lame duck but duly elected and sworn-in President of the United States somehow less valid than the actions of our colleagues who are not returning for whatever reason in a lame duck session of Congress? And I believe on its face that's an unconstitutional provision. If you're looking for constitutional issues, that's one. I also believe
reclaiming my time,
actually, I'm borrowing from her time.
which came from me,
Yeah.
which is due process, I think. But
I now ask the gentleman if he'll yield.
well, I just wanted to my interest was around the due process issue, whether it's constitutional or not, to limit the president's ability to pursue rules or that wasn't something I was interested in at this point, but I wanted to focus more on the due process issue and make sure that, federal employees, certainly there's been a lot of great things said about them, and I've got federal employees in my district, and I would wholeheartedly agree that they're very hardworking individuals. There's, American citizens, and they deserve every protection that we can afford them, just like anybody else does. And so that was my main concern. I appreciate the gentleman from North Carolina's perspective. That helps me through my decision process. But I also, like I said, I do appreciate very much the good lady from the District of Columbia raising that concern, because I agree with her that it is something that we should all be very, very concerned with. And but with that, Mr. Chairman, I appreciate very much.
Gentleman yields back his time. Thank you very much. I want to thank all three of you for not only your time today, but your interest in making sure that the quality and the proper management techniques, including the ability to save good employees and to work with those who might need help is included in our discussion. And I want to thank all three of you very, very much for taking time to be here. We have an awesome stenographer here. If you'll please make sure you leave anything you brought in writing for her. Mark, she speaks Texan.
We
but
love it.
She's
We
learning
thank
the
you,
North
Mr.
Carolina
No, we
style.
love it, Mr.
So this
Doesn't
way
need- doesn't need
this
a
way
big interpreter.
This way she can look at the real words you wrote down and try and copy those too.
Well said, Mr. Chairman. Thank you.
Thank you very much.
Thank the entire
I appreciate
committee.
all three of you being here. This now, is any other member that would seek to be heard on H.R. 4361? Any other member that would seek to give testimony on H.R. 4361? Seeing none, this now closes the hearing portion of H.R. 4361. Chairman, now being received a motion from the gentleman, the young chairman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 4361, the Federal Information Systems Safeguards Act of 2016, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-59 and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Finally, Section 2 of the rule provides that it shall be in order that at any time on the legislative day of July 7th, 2016, or July 8th, 2016, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15 relating to measures addressing the Federal Aviation Administration.
You've now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion to that? Seeing none, the vote will now be on the motion from the gentleman. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it. The ayes have it. Accordingly, the gentleman, Mr. Wood, I'm sorry?
Roll call?
Gentleman asks for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox? Aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Newhouse? Aye. Mr. Newhouse, aye. Ms. Flutter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 1 no.
The motion is agreed to, and accordingly, the gentleman, Mr. Woodall from Georgia, will be handling this for Republicans,
Mr. Polis for the Democrats.
and Mr. Poles for Democrats. I have just one announcement to make, and then we'll announce our next meeting. I'd like to recognize that we have at least 2 members of my intern staff that have not been here previous today. I see a couple members that have been here. Abby Callison from Plano, Texas, Baylor University, a senior, political science major, and Caitlin Smith from Dallas, Texas, who goes to the University of Texas at Austin, one of Tom's favorite schools to play in football. And she is a history and philosophy major. I want to welcome Caitlin and Abby to the Rules Committee and thank them for taking time to be here with us today. The last point that I would like to bring up is we're scheduled to meet tomorrow at 3:00 p.m. on the Senate version of the defense bill to facilitate getting into the conference and any other items which may be added. Is there any other work that is to be brought to the Rules Committee at this time? Yes, sir.
Have you decided when you guys are going to schedule your gun vote?
You know, it's a good question. The answer to that is that we are back after being gone a week. I anticipate that that there will be discussions that will be held. Tomorrow, there will be a conference of the Republican Conference. We're trying to make sure that our members not only understand but have feedback to that. And so that I would anticipate that as soon as that is done, that the majority leader will be announcing that schedule. Thank you. Good question. Thank you very much. Welcome back to my colleagues after a work week back home, and this completes our work for the day. Here you go, Bubba.